Neil.
Good afternoon, Your Honor.
Good afternoon. My understanding is that you were here for individual last name Collins, but I do not have a Collins on my arraignment list. So his, I believe, family was present. They just stepped out with the court officer to see if they could figure out what's going on with that file.
Yeah, we're trying to find that out too, Your Honor. I do know that he is in the jail, but there doesn't appear to be any information that's popping up online, and the prosecutor doesn't have anything in their system either. So we're kind of in a quandary, but thank you.
Okay, I'll keep you posted if I hear anything.
Thank you.
Okay. On the record in the matter of the people of the city of Lansing versus Ramon Gonzalez, file number is 23-03584FY. I also have 17-061820M, counsel appearance.
Assistant Public Defender John Lee on behalf of Ramon Gonzalez.
Are you Ramon Gonzalez?
Yes, Your Honor. Yes, I am.
Okay, Mr. Gonzalez, today's the date and time set for an arraignment. I do have a felony complaint here. The allegations are that on or about November 27, 2023 at East Michigan Ave at or near Clifford Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of child sexually abusive activity. The allegations is that you did attempt to prepare or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity, and that this was contrary to Michigan Compiled Law 750.145 C2A. There's a Sex Offender Registration Act notice. It says take notice. This is a tier 2 offense under the Sex Offender Registration Act. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. That's a felony. The maximum penalty is 20 years in prison and or $100,000 in fines. I'm not sure what happened to the video here. Okay, do you understand count 1?
Yes, Your Honor.
Okay, count 2 is computers, internet communicating with another to commit a crime, maximum imprisonment of 15 years or more or life. The allegations are that you did use the internet to communicate with a alleged minor, initials SS, for the purpose of committing sexual or child sexually abusive activity under Michigan Compiled Law 750.145 C2, where the victim or intended victim was believed by the defendant to be a minor. And this is contrary to Michigan Compiled Law 750.145 D2F. Again, there's a Sex Offender Registration Act notice. It says this is a tier 2 offense under the Sex Offender Registration Act if the underlying offense is a violation of MCL 750.145A or 750.145C. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. This is a felony, maximum penalty 20 years in prison and or $20,000 in fines, reimbursement to the government for expenses incurred in relation to violation may be ordered in a manner indicated by Michigan Compiled Law 769.1F. And a consecutive sentence may be imposed for any underlying offense. There's a count 3 of children accosting for immoral purposes. The allegations are that you did accost, entice, or solicit an individual you believed was a child less than 16 years of age with the intent to induce or force that individual to commit an immoral act, to submit to an act of sexual intercourse or an act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts contrary to Michigan Compiled Law 750.145. There's an HIV STD notice. It says take notice that the pursuant to Michigan Compiled Law 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, or for the presence of HIV or antibody to HIV if the judge determines there is reason to believe that the violation involved sexual penetration or exposure to the bodily fluid of the defendant. If the district court judge determines that testing is not required upon conviction, the judge orders the defendant then to be tested. There's another Sex Offender Registration Act notice stating this is a Tier 2 offense. Under the Sex Offender Registration Act, it's a Tier 3 offense if the defendant has a prior conviction for a Tier 4 offense. Count 3 is a felony, maximum penalty 4 years in prison and or $4,000 in fines. There's a count 4 of computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years, alleging that you did use a computer program, a computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit, accosting a minor for immoral purposes under MCL 750.145A-A, contrary to MCL 752.796 and 752.7973D. That's a felony, maximum penalty 7 years in prison and or $5,000 in fines and reimbursement to the government for expenses incurred in relation to this violation in a manner indicated by MCL 769.1F may be ordered upon conviction, and a consecutive sentence may be imposed for any underlying conviction. There's a count 5. Controlled substance, possession of cocaine, heroin, or other narcotic less than 25 grams, alleging that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, contrary to the Michigan Compiled Law 333.740328V. That's a felony. Maximum penalty is 4 years in prison and or $25,000 in fines. There's an habitual offender third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony, and that on or about November 5th, 2018, he was convicted of the offense of attempted home invasion first degree in violation of MCL 750.110A2 in the 29th Circuit Court for Clinton County, state of Michigan. And that on or about April 8th, 2019, he was convicted of the offense of conspiracy, bringing contraband into a correctional facility in violation of Michigan Compiled Law 800.2813 in the 29th Circuit Court for Clinton County, state of Michigan, and therefore defendant is subject to enhanced penalties provided by MCL 769.11 that enhances the maximum penalty on the primary offense to twice the maximum sentence or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge or the charges and the maximum penalty attached to those charges?
Yes, Your Honor, I do.
You have the right to be represented by an attorney. You are represented today by Mr. Lee of the Office of the Public Defender for the purposes only of your arraignment. You have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney and you economically qualify, you can be appointed the Public Defender's Office representation at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor, I do.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will proceed all the way to a jury trial. You have the right to trial, but before you go to trial, because you are being charged in this with 5 felony counts, in each count you have the right to a preliminary examination. You have the right to have preliminary examination within 21 days of today's date being the date that you're being arraigned. At the time of your preliminary examination, you have the right to require the prosecution to establish sufficient probable cause exists that a crime was committed and sufficient probable cause exists to charge you with those crimes. Do you understand the right so far?
Yes, Your Honor, I do.
You have the right to jury trial, and at the time of your trial, you enjoy the presumption of innocence. So you are innocent, sir, until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt at your trial. You have the right to confront your accusers and any witnesses that the prosecutor intends to call at your trial. You have the right to call your own witnesses to trial or present evidence at trial that you believe further a defense to these charges. You have the right to remain silent at trial and not have silence be used against you. Do you have any questions about those rights?
No, Your Honor, I do not.
You're currently scheduled for probable cause conference before Judge Tony Flores, Thursday, December 7th, 2023 at 8:30 in the morning. You may appear for that hearing via Zoom, or you can appear in person. You have a preliminary examination in person at the court Thursday, December 14th at 8:30 before Judge Flores. Did you get your notice to appear for Judge Flores?
Yes, Your Honor, I have it.
Okay, is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Okay, and he's entering a plea of not guilty?
Yes, he is, Your Honor.
Are you currently employed, Mr. Gonzalez?
Yes, Your Honor, I am.
And that's Ramon Gonzalez III, correct?
Yes, Your Honor, that is correct.
Okay, where are you employed?
Fiesta Chata, it's a Mexican restaurant on Lake Lansing Road, across from Eastwood Town Center. It's the old, formerly known as La Senorita.
Okay. What's your home address?
Current address 1201 South Holmes Street, HOLMES, Lansing, 48912.
What's your phone number?
517-204-2221.
Are you currently on probation or on parole?
No, Your Honor, I am not.
How many times have you missed court before?
Ever. Well, no, I take that back, Your Honor. I missed it once for city income tax.
People of the city of Lansing versus Ramon Gonzalez III, 17-6182. You were before Judge Clark back on June 11, 2018. For failure to pay income tax. Looks like you owe $1,356.81 since 2018. You've not made a single payment.
That is correct, Your Honor. I was incarcerated.
Until when?
From June until I was released in 2020 of September, where I made an arrangement, and then I was incarcerated again from 2021 till recently. So unfortunately, I just wasn't able to stay with the arrangements because I was incarcerated.
In 2021 until recently, what does recently mean?
May of 2023, ma'am. Your Honor. Excuse me.
You served the complete time, you're not on parole?
Oh, ma'am. No, Your Honor, I am not.
When are you gonna make a payment on this?
I can make a payment on this next week when I get my paycheck, Your Honor.
How much are you gonna pay?
I can make a payment of $50 weekly.
Counsel, you can address bond.
Thank you, Your Honor. As Your Honor has been discussing with Mr. Gonzalez, there is some criminal history there, including the attempted home invasion in 2018. We understand the seriousness of these charges. We would ask the court to consider that since his release, Mr. Gonzalez has been actively employed full-time at Fiesta Chara. He has been living with friends, but spending time with his family, all of which are here in Lansing. He has extensive ties to the community and does not present as a flight risk. We would just ask the court to consider that in consideration of his bond. Thank you, Your Honor.
Mr. Gonzalez has a pretty lengthy and concerning criminal history. Looks like he served 2 back-to-back terms of imprisonment, only recently being released several months ago this year. And now before the court on some very serious allegations that cause the court to believe that there's some concern for the public safety, that coupled with his previous criminal history. Bond will be set in the amount of 12,000. Personal recognizance, I'm sorry, cash surety. Personal recognizance will be denied. 12,000 cash surety. While out on bond, you have the following conditions. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. We're going to order that you have weekly PBT testing while out on bond. Not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. You need to report to all of your court dates as ordered, okay?
Yes, Your Honor.
You're not to engage in any assaultive or threatening behavior. Do you have any questions about your bond conditions?
No, Your Honor, I do not.
Okay, any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir.
Thank you, Mr. Lee. Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Nathan Barker, file number 23-03581FY, council appearance.
Assistant Public Defender John Lee on behalf of Nathan Robert Barker.
Okay, you're Mr. Nathan Robert Barker.
Yes, Your Honor.
Okay, Mr. Barker, today is the date we're moving forward with an arraignment. On your behalf, I have a felony complaint that alleges that on or about September 26, 2023 through November 27, 2023 at the area at or near Lansing Road and Davis Highway, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of child sexually abusive activity. The allegation is that you did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity contrary to Michigan Compiled Law 750.145C2A. This is a Tier 2 offense under the Sex Offender Registration Act. It is a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. This is a felony with the maximum penalty being 20 years in prison and or a fine of $100,000. There's a count 2 of computers using to commit a crime, maximum imprisonment of 20 years or more or life, alleging that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive activity under MCL 750.145C2, contrary to Michigan Compiled Law 752.796 and MCL 752.7973F. That's a felony. Count 2's maximum penalty is 20 years in prison and or $20,000 in fines and reimbursement to the government for expenses incurred in relation to the violation in a manner consistent or indicated by MCL 769.1F may be ordered if convicted, and a consecutive sentence may be imposed for the underlying conviction. Count 3, you're being charged with child accosting for immoral purposes, alleging that you did accost, entice, or solicit an individual that you believed was a child less than 16 years of age with the intent to induce or force that individual to commit an immoral act, to submit to an act of sexual intercourse or an act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts contrary to Michigan Compiled Law 750.145A. There is an HIV STD testing notice. It says, take notice that pursuant to MCL 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infections, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe that the violation involves sexual penetration or exposure to a bodily fluid of the defendant. If the district court judge determines that testing is not required upon conviction, the court must then order the defendant to be tested. Count 3 has a Sex Offender Registration Act notice saying this is a Tier 2 offense under the Sex Offender Registration Act. It is a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Count 3 is a felony, maximum penalty, 4 years in prison and or $4,000 in fines. Count 4, computers using to commit a crime, maximum imprisonment of 4 years or more but less than 10 years, alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit children accosting from immoral purposes, MCL 750.145A-A, and that this was done contrary to the Michigan Compiled Law 752.796 and Michigan Compiled Law 752.797 3D. Count 4 is a felony with the maximum penalty 7 years in prison and or $5,000 in fines, and reimbursement may be ordered to the government for expenses incurred in relation to violation in a manner indicated by MCL 769.1F. A consecutive sentence may be imposed for the underlying conviction. There is an habitual offender second offense notice. Says take notice that the defendant was previously convicted of a felony or attempt to commit a felony, and that on or about November 28th, 2017, he was convicted of the offense of criminal sexual crime in the second degree in violation of MCL 750.520C in the Circuit Court for Ionia County, State of Michigan, and therefore defendant is subject to the penalties provided by MCL 769.10, enhancing the maximum penalty to 1.5 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. You understand the charges and the maximum penalty attached to each charge.
Yes, Your Honor.
You have the right to counsel. You're represented by Mr. Lee today for the purposes only of your arraignment. You have the right to have counsel with you at each court appearance during this criminal prosecution. You have the right to have an attorney with you if you're questioned by law enforcement. If you cannot afford to hire an attorney on your own, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand that right?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will proceed to a jury trial. You're being charged in this matter, each count being a felony. And so you have the right to preliminary examination for each count. You have the right to have preliminary examination within 21 days of today's date, that being the date that you were arraigned. At the time of your preliminary examination, you have the right to require the prosecution to establish that they have sufficient evidence that a crime was committed and sufficient evidence to charge you with these crimes. If the matter proceeds beyond the preliminary examination, you will be bound over to the circuit court for trial. And at the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty, sir. You have the right to require the prosecutor to prove your guilt by proving each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court and cross-examine any of the witnesses or the accusers that the prosecutor calls against you. You have the right to present evidence at trial that you believe show a defense to the charges being brought against you, or call witnesses to testify on your behalf at your trial. Do you understand?
Yes, Your Honor.
The rights that I just stated to you?
Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
For the purposes of his arraignment, how does he want to plead?
Not guilty, Your Honor.
You're currently scheduled for probable cause conference before Judge Tony Flores, December 7th, 2023 at 8:30 in the morning. You have a preliminary examination before Judge Flores, December 14th, 2023 at 8:30 in the morning. Your preliminary examination is held in person at the court. However, for your probable cause conference, you can appear either via Zoom or in person, okay?
Yes, ma'am.
Did you get a copy of the notice to appear for Judge Flores?
Good, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
Are you employed?
Yes, Your Honor.
Where's that?
I'm the manager at FCI Automation.
What's your home address?
13724 East Kathleen Lane, Grand Ledge, Michigan, 48837.
What's your phone number?
517-626-0755.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Barker reports, and iChat confirms that he has only a couple of criminal convictions in his history. Possession of marijuana, operating as a minor with any blood alcohol some 20 years ago. And more recently, approximately 8 years ago, a criminal sexual conduct second. Otherwise, no criminal history. We understand that the court will have concerns for his previous convictions as well as the seriousness of these charges. We would ask the court to also consider that Mr. Barker is a full-time employee and manager at FCI Automation. He is the father of a child, raising a child in his home. He has also got extensive ties to the community, has lived in the Lansing area his whole life. His mom, his kids, his job, everything is here. And we would encourage the court to use as many bond conditions and or tethers as possible to eliminate the need for as much bond as possible. But we leave, of course, bond and all other considerations to the court, and thank the court for its time.
Okay, a review of his prior criminal history does confirm there are prior convictions. Again, it was operating with a minor with the blood alcohol content. He is being charged as an habitual offender due to the felony convictions of criminal sexual conduct from 2017. And then in this matter, 4 counts. So he's facing 1 1/2 times the sentence of 20 years and or $100,000, a very serious and steep penalty for serious allegations. There is concern before the court that the defendant is before the court currently on matters that he has displayed a recent pattern of similar behavior in the past. And also the allegations of as alleged would be considered a violent felony offense. For those reasons, a bond will be set to ensure the public safety and the safety of the minors in the public. There is a bond set at $20,000 cash surety. While out on bond, you're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. You're not to engage in any assaultive or threatening behavior. Do you have any questions?
No, Your Honor, but could I speak?
You have the right to remain silent. Anything you say, anything that you put in writing can be used against you, so long as you understand that. You feel free to say what you want to say.
Your Honor, I was just hoping with the bond, maybe you would do the 10%. I don't have anything I can put down as collateral for a bond agent. I do have $2,000 I can
I
put
recognize
down.
that you misunderstood. I recognize you misunderstood this to be a negotiation about your bond, but it's not. So your bond is $20,000 cash surety. Any additional questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Thank you. You're all set. On the record, in the matter of the people of the state of Michigan versus Lionel Silva, file number 23-03583FY, counsel appearance.
Assistant Public Defender John Lee, appearing on behalf of Lionel Ruiz Silva.
Are you Lionel Silva?
Yeah.
Okay, Mr. Silva, today's the date set for an arraignment. I have a felony complaint that alleges that on or about November 27th, 2023 at Vine and Clifford, City of Lansing, Eagan County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of child sexually abusive activity. It alleges that you did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any sexually child abusive activity contrary to Michigan Compiled Law 750.145C2A. This is a Sex Offender Registration Act notice that says this is a Tier 2 offense under the Sex Offender Registration Act, and it's a Tier 3 offense if you had a prior conviction for a Tier 2 offense. This is a felony, maximum penalty 20 years and or $100,000 in fines. There's a count 2 of computers using to commit a crime, maximum imprisonment of 20 years or more or life, alleging that you did use a computer program, computer system, or a computer network to commit, attempt to commit, conspire to commit, or solicit to commit child sexually abusive activity, MCL 750.145C2, and that this was done contrary to Michigan Compiled Law 752.796 and Michigan Compiled Law 752.7973F. This is a felony. Maximum penalty is 20 years in prison and or $20,000 in fines, and reimbursement to the government may be ordered for expenses incurred in relation to the violation in a manner indicated by MCL 769.1F. A consecutive sentence may be imposed for the underlying conviction. There's a count 3 of children accosting for immoral purposes. It alleges that you did accost, entice, or solicit an individual that you believe was a child less than 16 years of age with the intent to induce or force the individual to commit an immoral act, to submit to an act of sexual intercourse or an act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts contrary to MCL 750.145A. Count 3 has a HIV STD testing notice. It states that upon bind over to the circuit court pursuant to MCL 333.5129, the district court judge shall order the defendant to be tested for sexually transmitted disease, hepatitis B infection, and for the presence of HIV or antibody to HIV. If the judge determines there's a reason to believe the violation involved sexual penetration or exposure to a body fluid of the defendant. If the district judge determines that testing is not required, then upon conviction, the court must order the defendant to be tested. Count 3 also has a Sex Offender Registration Act notice. It says this is a Tier 2 offense under the Sex Offender Registration Act. It is a Tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 3 is a felony. Maximum penalty is 4 years and or $4,000 in fines. Do you have a staple? No, remover. Okay, there's a count 4. It says computers using to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years. The allegations are that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit the crime of children accosting for immoral purposes, MCL 750.145A-A, contrary to MCL 752.796 and MCL 752.797-3D. That's a felony. Maximum penalty 7 years in prison and or $5,000 in fines, and reimbursement may be ordered to the government for expenses incurred in relation to the violation in a manner indicated by MCL 769.1F. Do you understand each of the charges read there and each of the maximum penalties?
Yes.
Okay, you have the right to counsel. You have the right to be represented by counsel at each stage and each appearance under the criminal prosecution, and you have the right to have an attorney with you to represent you if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, the matter will proceed to a jury trial. You're being charged with 4 felony counts. In each of those counts, you have the right to a preliminary examination. You have the right to have that preliminary examination within 21 days of the date of your arraignment. At the time of your preliminary examination, you have the right to have the prosecutor establish that they have sufficient evidence to support that a crime was committed, and it's sufficient evidence to support probable cause to charge you with those crimes. Do you understand your right so far?
Yes.
You have the right to a jury trial. At the time of jury trial, you have the right to the presumption of innocence. You have the right to remain silent at your trial and not have silence be used to prove or imply that you're guilty. You have the right to confront in court any of your accusers or any witness that the prosecutor intends to call against you. You have the right to call your own witnesses to your trial or present evidence at trial that you believe further defense to the charges being brought against you. You're currently scheduled for probable cause conference before Judge Stacia Buchanan, Thursday, December 7th at 8:30 in the morning. You have a preliminary examination before Judge Buchanan, Thursday, December 14th at 9:30 in the morning. Your preliminary examination is in person at the court. You may, however, appear for your probable cause conference via Zoom or in person. Did you get your notice to appear? Did you get a notice to appear? Okay, do you have any questions?
No.
Okay, is he requesting court-appointed counsel?
Yes, he is, Your Honor.
How does he want to plead?
Not guilty.
The court will enter a plea of not guilty on your behalf. Are you employed, Mr. Silva?
Yes.
Where?
It's Hilo Acres on Westphalia, Michigan.
What's your phone number?
517-977-2157.
What's your home address?
4118 Donald Street in Lansing, Michigan.
Are you currently on probation or on parole?
No.
Do you have any other matters pending?
No.
You can address bond counsel.
Thank you, Your Honor. Your Honor, Mr. Silva only shows one prior conviction, that being for a solicitation in 2007, so some 16 years ago. He has been living here in Lansing for the past 26 years, currently lives with his son and is a father, of course, to him, but also, as he reports, is actively engaged in employment and is otherwise a responsible member of the community. We ask the court to consider that when considering bond for Mr. Silva.
The defendant in this case is being charged with 4 felony counts, one being a violent felony, and he does have some prior criminal history, although it was quite some time ago. The court does still have concern based on the allegation alleged for the safety of the public. A bond will be set in the amount of $12,000 cash surety. While out on bond, you're not to travel outside the state without prior approval of the court. You're not to possess or purchase a firearm or any other dangerous weapon. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of your release. You're not to use any drugs or alcohol unless you have a valid prescription. Do you have any questions about your bond?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir.
Thank you.
Ms. Hartwig, I'm sorry?
So I came to get my fingerprints done, and the third floor said that their fingerprint thing isn't working right now or something, to come talk to you, or maybe like just let you know.
The third floor said the fingerprints not working?
Yeah, they actually wouldn't even let me up to the third floor, they just called them on the phone.
Is that Officer Lawrence in there? Are
Yes,
you,
ma'am.
are you all not able to do fingerprints down there today?
I will check with Sergeant Hewitt right now. He would know more about that than myself.
Thank you.
Yes, Your Honor.
I just wondered if you were able to do fingerprints down there, because I have a defendant here on another case that's has had her order for fingerprints for quite some time. She said that she was told she couldn't get them done down there today.
They were working on the sink. They can send them, if she comes down now, we can get her fingerprinted. I think they're done working on the room that was in there.
Oh, okay, sounds good. You can go down now, ma'am. Thank you. I thought he was that. I thought Sergeant Hewitt was retired. I guess not. Okay, back on the record here, and now I'm in the matter of the people of the state of Michigan versus Christopher Wolf. File number 23-03582. Council appearance.
Assistant Public Defender John Lee appearing on behalf of Christopher Wolf.
Okay, today's the date and time that's set for an arraignment. Here, Mr. Christopher Wolf.
Yes, Your Honor.
Okay, I have a felony complaint here. The complaint alleges that on or about November 27, 2023 at 5185 Wise Road, City of Lansing, Ingham County, State of Michigan, you did allegedly in count 1 commit the act of child sexually abusive activity. The allegation is that you did attempt, prepare, or conspire to arrange for, produce, make, copy, reproduce, or finance any child sexually abusive activity contrary to MCL 750.145C2A. This is a Tier 2 offense under the Sex Offender Registration Act. It is a Tier 3 offense, however, if you have a prior conviction for a Tier 2 offense. This is a felony with a maximum penalty of 20 years in prison and or $100,000 in fines. There's a count 2, of computers using to commit a crime, maximum imprisonment of 20 years or more or life. It alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive activity, MCL 750.145C2, and that this was contrary to Michigan Compile Law 752.796 and Michigan Compile Law 752.7973F. Maximum penalty for count 2, it's a felony, 20 years in prison and or $20,000 in fines. And you may be ordered to reimburse the government for expenses incurred in relation to violation in a manner indicated in MCL 769.1F. A consecutive sentence may be imposed for the underlying conviction. Count 3, child accosting for immoral purposes, alleges that you did accost, entice, or solicit an individual you believe was a child less than 16 years of age with the intent to induce or force the individual to commit an immoral act, to submit to an act of sexual intercourse, or to act of gross indecency or other act of depravity or delinquency, or did encourage the individual to engage in one of these acts contrary to Michigan Compile Law 750.145A. There's an HIV STD testing notice attached to count 3. It states here, pursuant to MCL 333.5129, upon bind over to the circuit court or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV. If the judge determines there's reason to believe the violation involves sexual penetration or exposure to bodily fluid of the defendant. If the district judge determines that testing is not required, then upon conviction, the court must order the defendant to be tested. Count 3 is a tier 2 offense under the Sex Offender Registration Act, and it's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 3 is a felony, maximum penalty 4 years and or $4,000 in fines. Count 4, computers using to commit a crime, computers, maximum imprisonment of 4 years or more, but less than 10 years. Alleging that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit children accosting for immoral purposes, MCL 750.145A-A. That's a felony. Maximum penalty is 7 years in prison and or $5,000 in fines. Reimbursement to the government may be ordered for expenses incurred in relation to the violation in a manner indicated by MCL 769.1F, and a consecutive sentence may be imposed for the underlying conviction. Do you understand each count 1 through 4 and the maximum penalties attached?
Yes, Your Honor.
You have the right to counsel, and Mr. Lee from the Public Defender's Office is representing you today solely for the purposes of your arraignment. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution. You have the right to have an attorney with you to represent you if you are questioned or cross-examined by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand your rights so far?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. You have the right to have a preliminary examination in each count because each count is a felony. You have the right to preliminary examination within 21 days of the date of your arraignment, unless the court finds a good cause to go beyond that timeline or you waive the timeline. At the time of your preliminary examination, you have the right to require the prosecution to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with each of these crimes. You have the right to a jury trial. You have the right to presumption of innocence. You're innocent until proven guilty. You have the right to remain silent at your trial and not have silence be used against you. You have the right to confront and cross-examine in court any of the witnesses or the accusers that the prosecutors calls against you, and you have the right to call your own witnesses to your trial, or you can present evidence at your trial that you believe further a defense to the charges being brought against you. Do you have any questions about those rights? Do you have any questions about those rights?
No, Your Honor.
Okay. Is he requesting court-appointed counsel?
No, Your Honor, he will retain counsel.
How is he pleading for the purposes of his arraignment?
Not guilty.
You're currently scheduled for probable cause conference Friday, December 8th, 2023 at 8 o'clock in the morning before Judge Cynthia Ward. You have a preliminary examination in person before Judge Ward, December 15th at 8:30 in the morning. Did you get a copy of your notice?
Yes, Your Honor.
Are you currently employed?
Yes, Your Honor.
Where are you employed?
I am employed by the state of Michigan. I'm an administrative law judge.
What's your phone number?
517-290-8869.
Are you currently on probation or on parole?
No, Your Honor.
Are you on bond and any other matters?
Your Honor.
Are you at this address on Snapdragon Lane?
Yes, Your Honor.
You can address bond counsel.
Thank you, Your Honor. Your Honor, Mr. Wolf reports one prior conviction, reckless driving in Las Vegas, Nevada, approximately 14 years ago. No convictions here in the state of Michigan. He is a full-time employee of the state of Michigan, working as an administrative law judge, has lived here in the greater Lansing area for approximately 15 years, currently situated in the suburb of DeWitt. We would ask the court to consider his clean record and his full-time employment and responsibilities as a family man here in town when considering his bond. Thank you.
Have you ever missed court in the past?
Sorry, Your
Can
Honor,
you hear
what was
me in the
that?
jail? Have you missed court in the past, sir?
Never, Your Honor.
Okay, the defendant is before the court for a violent felony offense. I do not see any prior criminal history here noted on his criminal record. file also indicates there is a low risk factor apparent here. I will release the defendant on personal recognizance. Bond will be set at 20,000 personal recognizance with the following conditions. You need to report to pretrial services for supervision while out on release. You're not to have or possess or purchase any firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to engage in any assaultive or threatening behavior. Do you have any questions about your bond conditions? Do you have any questions about your bond conditions?
I apologize. No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir.
Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Lauren Watson, file number 23-03588FY and 23-01140OM. Are you all set, ma'am?
So they signed this on here and it's like, it's already in the system, it's CCH, but I don't need to take my fingerprints for anything else, so I told them I come back up here because they said that last time and then we're here again.
They signed the certificate of fingerprinting, so
They wrote that number on there.
Come back
So,
over
oh, I'm so sorry.
they need to have, it needs to be entered in JIS and then you'll be all set, okay?
Okay.
Thank you. Okay, are you Lauren Watson?
Ma'am.
Okay, Ms. Watson, today's the date and time set for an arraignment. I have two files here. 3-03588 first, I have a felony complaint that alleges that on or about November 28, 2023 at 3222 South Martin, it should say Martin Luther King Boulevard, number 27A, City of Lansing, Ingham County, State of Michigan. You did allegedly in count 1 commit the act of controlled substance possession of methamphetamine ecstasy. The allegation is that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032BI. Count 1 is a felony with a maximum penalty of 10 years in prison and or $15,000 in fines. There's a count 2 of attempted police officer assaulting, resisting, obstructing, alleging that you did attempt to commit the following listed offense and in the attempt did act towards the commission of that offense, but failed in the perpetuation or was prevented in the execution thereof, contrary to MCL 750.92. You allegedly assaulted, battered, wound, resisted, obstructed, opposed, or endangered Officer Ethan Malek, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D. Count 1 is a misdemeanor. Sorry, that's count 2. It's a misdemeanor with a maximum penalty of 1 year and or $1,000 in fines. There's a habitual offender second offense notice. However, it says take notice. The defendant was previously convicted of the felony or attempted to commit a felony in that on or about July 22nd, 2010. She was convicted of the offense of attempted police officer assaulting, resisting, obstructing in violation of MCL 750.81. In the 30th Circuit Court for Ingham County, State of Michigan. I don't know what's going on. Therefore, defendant is subject to the enhanced penalties provided by MCL 769.1 0, that enhances the penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges there and the maximum penalty and the habitual offender notice?
Yes, I do.
Excuse me? Okay. You have the right to be represented by counsel. Mr. Lee from the Office of the Public Defender is representing you only for your arraignment. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution, and you have the right to counsel if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request the public defense office to represent you at the expense of the public. Do you understand your right to counsel?
Yes.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, the matter will continue to a trial. You have the right to a jury trial, but you are in this matter being charged with a felony, which means you have the right to a preliminary examination for that felony. You have the right to have the preliminary examination within 21 days of today's date. Do you understand that?
Yes.
You a little tired?
Yeah. I'm feel good.
Oh, I'm sure. Okay, so you have the right to have a preliminary examination and require the prosecutor to establish whether or not they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crimes alleged. Do you understand that?
Yes.
You have the right to proceed to jury trial, and you have the right to presumption of innocence at your trial. You have the right to remain silent at trial and not have silence be used against you. You still awake?
Yes.
Okay, well, keep your head up so we can see you, okay?
Same thing you're saying right here on the table. This is the same thing I was reading.
I recognize that. You were supposed to read it before we got here, okay? Now you're listening to me.
I'm reading this as well as I'm listening to you, ma'am.
Okay, I just want to make sure, okay? Okay, and so you have the right to confront and cross-examine any other witnesses the prosecutor intends to call against you. You have the right to call your own witnesses, or you can present evidence at trial that you believe further defense of the charges being brought against you. Do you have any questions about any of your rights?
No.
Are you requesting court-appointed counsel?
No.
You're gonna hire an attorney?
No.
So what's your plan? You're gonna represent yourself?
Yes.
Okay. So you're declining counsel at this time. The court will make a note of that. How does she want to plead, Mr. Lee?
I'm not guilty, Your Honor.
Are you currently on probation?
No.
Are you on parole?
No.
Do you have any other matters pending?
Yes.
Which courts?
This one. It is for falsifying information to Officer Craig Flesser, number 109.
Does she have a retail fraud in there? It's a pending? Yeah. You also have a retail fraud pending. Did you forget about that?
No.
Okay, so you only mentioned one matter pending. Do you have anything else pending, ma'am?
I don't think so.
I'm just scheduled for arraignment on December 14th. Well, they should have brought the file because they gave me our other file for this one. What's your home address?
3529 Glenwood.
What's your phone number?
928-0400.
What's the area code?
517.
Are you employed?
No.
Currently scheduled for probable cause conference before Judge Cynthia Ward, December 8th at 8 o'clock in the morning. And you have a preliminary examination before Judge Ward, December 15th at 8:30 in the morning. Did you get your notice to appear?
Yes.
Have you ever missed court in the past?
Yes, I showed up late and I was in video court in the wrong courtroom for like an hour, last 2 times.
Is that the only time you missed court?
Yes.
Oh, okay. File number 23-01140. People of the city of Lansing versus Lauren Amanda Watson. Says here, May 2nd, 2023, defendant failed to appear. May 23rd, 2023, defendant failed to appear. October 3rd, 2023, defendant failed to appear.
October 3rd.
October 31st, 2023, defendant failed to appear. November 21st, defendant failed to appear. You can address bond counsel.
Thank you, Your Honor. Ms. Watson has clearly demonstrated some inconsistencies in her commitment to resolving issues before the court, and we understand the court's concerns. We also understand that these are fairly serious charges that she is facing in this matter. Therefore, we would only ask that the court consider that she does not present as somebody who will flee the Lansing area. However, we understand the court has concerns about whether or not she will actually appear in court. So we leave it to the court's discretion and thank the court for its time.
Thank you. The defendant is already under court order and fails to appear in court multiple times, and she's not honest either. Bond in file number 23-03588 is going to be set at $15,000, 10%. Bond in file number 23-01140 will be set in the amount of $2,000, 10%. No PR, 14 days. While out on bond, you're going to test weekly.
So I'm not getting an identity without money?
Well,
because like on the 31st, I did come at 3 o'clock. Court was at 2 and I was in there at 3.
Okay.
And I ran away, got arraigned in.
Okay.
So
you can be remanded. You can be remanded if you like. You can remand her. I'll move on. You can remand her. Thank you. On the record in the matter of the people of the state of Michigan versus Kevin Price, file numbers 23-03589 FY and 23-00060. Counsel appearance.
Assistant Public Defender John Lee on behalf of Kevin Lamont Price.
Is Kevin Lamont Price?
Yes, ma'am.
Okay, Mr. Price, I have 2 files for you. We'll take the felony file first. I have a felony complaint here that alleges that on or about November 28, 2023 at 3606 Malibu Drive, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of robbery unarmed. It alleges that you did, in the course of committing a larceny of a cell phone, use force or violence against a person present, that being a Crystal Barclay, that this was contrary to MCL 750.530. That's a felony. Maximum penalty is 15 years in prison, and your DNA is to be taken upon arrest. There's a count 2 of assault with intent to do great bodily harm, less than murder or by strangulation. It alleges that you did make an assault upon a Crystal Barclay by strangulation or suffocation, contrary to MCL 750.84. This is a felony. Maximum penalty 10 years in prison or $5,000 in fines. DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3, police officer assaulting, resisting, obstructing, alleging that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Owen Rogus, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties, and that this was contrary to MCL 750.81D1. This is a felony with a maximum penalty 2 years and $2,000 in fines, and a consecutive sentence may be imposed if the assault was committed in a place of confinement or if the violation arises from the same transaction as another. There's a count 4 of domestic violence, alleging that you did make an assault or assault and battery upon a Crystal Barclay, an individual with whom you have a child in common, or a resident or former resident of your household, or an individual with whom you have a dating relationship, contrary to MCL 750.812. Restitution may be ordered if convicted, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 4 is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. And a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. However, there is a habitual offender second offense notice. It says take notice that the defendant was previously convicted of the felony or attempt to commit a felony in that on or about February 10, 2007, he was convicted of the offense of receiving and concealing a motor vehicle in violation of MCL 750.5357 in the 30th Circuit Court for Ingham County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.10, which is 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges and the maximum penalty on each charge?
Yes, Your Honor.
Okay, you have the right to counsel, and Mr. Lee is representing you today for your arraignment only. You have the right to request to have the public defense office appointed to represent you if you can't afford to hire your own attorney. Do you understand your right to counsel?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, the matter will proceed to a jury trial. You are being charged in this matter with 3 counts that are felonies. In each felony matter, you have the right to a preliminary examination, and you have the right to have examination within 21 days of your arraignment, unless you waive that timeline or the court finds good cause to waive that timeline. At the time of your preliminary examination, you have the right to require the prosecution to put on evidence to establish probable cause that a crime was committed and probable cause to charge you with the crimes. You have the right to a trial. At the time of your trial, you have the right to jury trial. At the time of the jury trial, you have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to remain silent and not have silence be used against you. You have the right to see, hear, or question any other witnesses in court the prosecutor calls against you. You have the right to call your own witnesses or present evidence that you believe further defense to the charge being brought against you. And you have the right to require you to prove each element of the charges beyond a reasonable doubt at your trial. Do you have any questions about those rights?
No, Your Honor.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
And how does he want to plead?
Not guilty.
You're currently scheduled for a probable cause conference before Judge Stacia Buchanan Thursday, December 7th at 9 a.m. You have a preliminary examination before Judge Buchanan Thursday, December 14th at 10 o'clock in the morning. Your preliminary examination is in person at the court. You can appear via Zoom or in person for your probable cause conference. Do you understand that?
Yes, Your Honor.
Did you get your notice to appear?
Yes, Your Honor.
Okay, are you employed?
Not currently.
How do you support yourself?
I do all types of things. I do breaks, cut hair. I do this little trash thing with my cousin. Make a couple dollars throughout the week.
Gotcha. What's your home address?
Well, it was Malibu, but 5513 South Martin Luther King.
Say that again.
5513 South Martin Luther King.
Whose address is that?
That's mine and a friend.
What's your phone number?
517-505-8810.
Are you currently on probation?
Oh, yeah.
You said no?
Oh, yes, no.
Excuse me?
No, I'm not on probation, Your Honor.
Okay, thank you. You're not on parole?
No, Your Honor.
Do you have any other matters pending?
No, Your Honor.
People of the city of Lansing versus Kevin Lamont Price, file number 23-00060. And this matter, it looks like you were scheduled for an arraignment back on January 19th. I don't have indication where you appeared for that arraignment. It says you failed to appear, but then it looks like you must have somehow appeared later to be arraigned. Oh, no,
Yeah,
you weren't. You never came to be arraigned, so we're gonna arraign you today. I have a misdemeanor complaint here. It alleges that on or about May 8th, 2022, in the area or vicinity of West Mount Hope Ave in Davis, in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, while an officer was attempting to apprehend a person in violation of the law contrary to MCL or the provisions of the Code of Lansing 602.06, that you did willfully fail to obey the law command of a law enforcement officer or to stop or to halt, and that this is a maximum penalty misdemeanor, 90 days in jail and or $500 in fines. Do you understand the charge and the penalty?
Yes, Your Honor.
Okay, and you also have the same rights that we've already gone over as it relates to this file, including your right to counsel, okay?
Yes.
So the court will note that you're also making a request for court-appointed counsel in this file. That's accurate, Mr. Lee?
Yes, Your Honor.
And then the court will enter a plea of not guilty on your behalf. And that matter will be scheduled for pre-trial conference December 11th at 9:30 in the morning before Judge Stacia Buchanan, okay?
Yes, Your Honor.
Okay, counsel, you can address bond.
Thank you, Your Honor. Mr. Price does report some prior contact with the criminal justice system. As far back as 2007, there was a receiving and concealing conviction. He has had some traffic-related convictions and some more serious matters along the way. We would ask the court to consider that he does not pose a flight risk. He has been in Lansing since 1999. His family is here. He has other family in Grand Rapids, but everybody's in Michigan, and would leave to the court's discretion all other matters concerning bond.
I do see a quite lengthy history for the defendant. There are a substantial amount of charges on his criminal history for violent interactions, primarily domestic violence. Literally over 6 times he's been charged. There's been no convictions. And in the matter before the court, he's being charged with a domestic violence, but in addition to that, with a unarmed robbery and assault with intent to do great bodily harm, less than murder or by strangulation, and with allegedly police officer assaulting, resisting, obstructing. I don't doubt that he has family that lives here and that he probably won't leave the state of Michigan, but I do believe that he is a threat to the public safety. So bond will be set in the amount of $10,000 cash surety with GPS tether. And victim notification, if possible. While out on bond, you're not to have contact directly or indirectly with the alleged victim, Crystal Barclay. You understand that?
Yes, ma'am. Your Honor.
You're not to be within 2,000 feet of wherever she is. You're not to have anybody else contact her on your behalf. Do you understand?
Yes, Your Honor.
You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to travel out the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours for supervision. Do you have any questions? Bond in the city file will be set at 500 personal recognizance. You need to report to all of your future court dates. Any questions on that file?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set. Mr. Akanicki, which matter were you here for?
Yellow Dog's catalyst versus Angel Jackson. She texted me and said she was trying to download Zoom, so I don't know if she's on there.
She is not, and she's not appeared in my meeting room at all since I've been on here, so a default can enter.
Okay, I had an agreement for a conditional dismissal with her, but I don't know. So.
But she did not appear. I can reset it if you'd like.
I guess, Your Honor, it would be better just to reset it based on what I told her, so.
Okay, we'll reset that. December 6th at 1:30.
Thank you, Your Honor.
You're welcome. Sounds good. I don't know if did our 245 people show up? Do we know? Was there another attorney that appeared?
Yes, and then he walked back up.
Do we know if he's out? Can we see if he's out there? Because I don't want him sitting, if I could just resolve his case. And then Tay Mitchell and Joy Monroe, are they there? Is there a Tay Mitchell or Joy Monroe out there? Counsel, did you resolve your matter? Were you able to resolve your matter?
No. The defendants are not here. It's 45 and second quarter.
Was Khalil Tanner and Shalia Daniel? All connected. No problem. Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Jabriel McGriff, file number 23-03590. Counsel appearance.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Jabriel McGriff.
Thank you. Mr. McGriff, your name's Jabriel McGriff?
Yes, Your Honor.
Okay, Mr. McGriff, I have here a
Ma'am?
felony complaint. Can you hear me?
Yes, ma'am.
Okay, I have here a felony complaint. It alleges that on or about November 29, 2023, at the area of Westland Way in South Butler, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of police officer assaulting, resisting, obstructing. The allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Donovan Moore, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D1. Count 1 is a felony with the maximum penalty 2 years in prison and or $2,000 in fines, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. There's a habitual offender third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony, and that on or about November 1st, 2023, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the Circuit Court for Ingham County, and that on or about February 8th, 2022, he was convicted of the offense of resisting and obstructing in a violation of MCL 750.81D1 in the Circuit Court for Ingham County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.11 that enhances the penalty in count 1 to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term on the first offense. Do you understand the charge, sir, and the maximum penalty and the habitual offender third offense notice?
You said this is my third Arnold.
That's if you've been charged as an habitual offender third offense notice. And I read the dates of the previous convictions that they indicate that you have been convicted of.
You said November 1st, 2023.
I said that on or about November 1st, 2023, it says he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227.
Okay. Yes, Your Honor, I understand.
Okay. Okay, you have the right to counsel. Mr. Lee is representing you today for your arraignment only. You have the right to have an attorney with you throughout the criminal prosecution at all of your court appearances. You have the right to have an attorney to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public, okay?
Okay.
You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. You have the right in this matter to proceed to a preliminary examination. You have the right to have preliminary examination within 21 days of today's date unless you waive that timeline or the court finds good cause to go beyond the 21 days. At the time of preliminary examination, you have the right to require the prosecutor to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crimes. Do you understand your rights so far?
Yes, Your Honor.
You have the right to proceed to jury trial in this matter. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at a jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecutor calls against you, and you have the right to call your own witnesses to your trial or present evidence at your trial that you believe further defense to the charges being brought against you. Do you have any questions so far?
No, Your Honor.
Are you currently on probation?
Yes, Your Honor.
And you're not on probation for the November 1st, 2023 conviction. It's from another conviction from August 2023, correct?
I got sentenced on November 1st for everything.
Okay. So you pled guilty on November 1st and the circuit court sentenced you the same day?
No, that was for my height of probation. She canceled my height of probation. So when I had to go in front of her on November 1st, it was for the charge that I caught June 29th, 2022.
Yeah, I see a charge from June 30th, 2022, but I also see another charge from May 18th, 2022.
Yeah, the one that I caught in May was a misdemeanor. I got all of that. I got that charge with my probation. I got all of that taken care of for time shared, and then I just had to handle this.
Okay, and then you have a separate matter that you were dealing with under Hyder, not those two. It was a third matter, correct?
Yes, ma'am.
If you requesting court appointed counsel,
Yes, he is, Your Honor.
how does he want to plead?
Not guilty.
Okay. Are you employed?
Yes, Your Honor.
Where?
Fox Works LLC.
What's your home address?
1233 West Hillsdale.
And your phone number?
517-505-1866.
You're currently scheduled for probable cause conference before Judge Tony Flores, December 7th at 9 a.m. You have a preliminary examination before Judge Flores, December 14th at 9 a.m. Your probable cause conference can be via Zoom or you can come in person. Your preliminary examination is in person. Did you get your notice to appear?
Yes, Your Honor.
address bond, counsel.
Thank you, Your Honor. Mr. McGriff's criminal history does include possession of weapons. I don't know if there are any allegations that he actually used the weapons for any. I am not aware of any of those types of allegations, Your Honor. He is currently facing an R&O charge, which is a crime of violence, and we understand that the court might have some reservations and or concerns about the public safety in regard to Mr. McGriff. We would ask the court to consider perhaps bond conditions and tethers and other means of restraint and or control. We would also remind the court that he is employed full-time at Watts Works and has lived here in Lansing his whole life. His primary support structure being his mother and his grandmother. So he does not present as a flight risk, Your Honor. We ask the court in consideration of those things for a bond on Mr. McGriff.
Thank you. Mr. McGriff is quite young. See a date of birth that would make him barely 20 years old. However, he's been quite busy according to his criminal history, and I see multiple convictions since 2019. He's currently on bond. Currently has matters pending before the court in a matter that he's on, or matters that he's on probation for. And then the new allegation being a crime of violence and a habitual offense, third notice being attached. The court does believe that there is a threat to the public safety. So personal recognizance bond will not be granted. Bond will be set in the amount of $5,000 cash surety. While out on bond, you're not to possess a firearm or any other dangerous weapon. What are your work hours?
I work every day from 7 a.m. to 5 p.m.
Okay, while out on bond, you're going to be on GPS tether and you're going to have a curfew. And you're expected to be indoors no later than 8 p.m. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're going to PBT randomly. You're going to check in with probation within 48 hours of your release. Do you have any questions about your bond?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. On the record, in the matter of the people of the state of Michigan versus de Montreal Stewart, file number 23-034559 FY, counsel appearance.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of de Montreal Stewart.
De Montreal Stewart. Are you de Montreal Stewart?
Yes.
Okay, Mr. Stewart, today's the date I'm going to proceed with your arraignment. And I do have a felony complaint here that alleges that on or about August 27, 2023 at 540 West Willow Street, apartment D22, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act of assault with intent to do great bodily harm, less than murder, or by strangulation. It alleges that you did make an assault upon Alyssa Johnson by strangulation or suffocation, contrary to MCL 750.84. This is a felony with the maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 2 of domestic violence, alleging that you did make an assault or assault and battery upon Alyssa Johnson, an individual with whom you had a dating relationship, contrary to MCL 750.812. Restitution may be ordered if convicted, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. Count 2 is a misdemeanor with a maximum penalty of 90 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is a third offense notice, however. It says take notice. The defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, individual with whom he had a dating relationship, individual with whom he had a child in common, or resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.812 on or about October 19, 2015, and by violating MCL 750.81A on or about March 6, 2023, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815. That enhances count 2 to a felony. Maximum penalty, 5 years in prison and or $5,000 in fines, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's an habitual offender. Second offense notice. It says take notice that the defendant was previously convicted of a felony or attempt to commit a felony in that on or about March 6, 2023. He was convicted of the offense of aggravated domestic violence, second offense in violation of MCL 750.81A3 in the 30th Circuit Court for Ingham County, and therefore the defendant is subject to the penalties provided by MCL 769.10, 1 1/2 times the maximum sentence on the primary offense or lesser a term. The maximum penalty cannot be less than the maximum term for the first violation. Do you understand the charges read in count 1 and 2, the third offense notice and the habitual offense second offense notice?
Yes, ma'am.
You have the right to counsel. Mr. Lee is representing you only for your arraignment today. You have a right to have a counsel represent you at all of your court dates and court appearances. And you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. You understand that, correct?
Yes, ma'am.
Okay, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed to a jury trial. You're being charged with felonies in this matter. You have the right in each count 1 and count 2, because count 2 is enhanced, to have a preliminary examination within 21 days of today's date. You have the right to have that examination within that timeline unless you waive the timeline or the court finds good cause to go beyond that 21-day timeline. At the time of your examination, you have the right to require the prosecution to put forth evidence to establish sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crimes. You have the right to proceed to jury trial. You have the right to remain silent at your jury trial and not have silence be used against you. You have the right to confront in court your accusers and cross-examine them. You have the right to call your own witnesses or present evidence that you believe further a defense to the charges being brought against you. Do you have any questions about your rights?
No, Your Honor.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf. Are you currently employed?
No,
Can you say that again?
no, Your Honor.
What's your home address?
5808 Hillcrest.
What's your phone number?
I do not have one.
Are you currently on probation? Excuse me?
No.
Are you on parole?
No.
You have bond pending anyplace else?
No.
You had a conviction of aggravated domestic violence in March of this year. Did you hear me? I can't hear his response.
No, I did not.
Okay, well, your criminal history that I have here indicates that you were previously convicted. Let's see, is this the right date of birth? Let's see. It's the same date of birth. To Montreal Shaquille Stewart?
Yes.
Okay. According to our records, you were not only convicted of aggravated domestic violence, second offense this year, but that you are currently on probation. You're disputing that? Do you understand what I'm saying?
Yes.
Are you disputing that?
No.
So you are on probation?
Yes.
So why did you tell me no when I asked you were you on probation?
I wasn't sure.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Stewart has prior convictions, as the court has taken note, for domestic violence and aggravated domestic violence. There does seem to be domestic violence issues. I don't know if this is all the same complainant, but that is obvious and apparent. So we understand that the court will want to take measures to protect the complaining witness and perhaps even society at large. But we would ask the court to also remember that Mr. Stewart is a lifelong resident of Lansing, has extensive family here, and does not present as a flight risk. But thank you, Your Honor.
Okay. I'm concerned that I asked the defendant, was he on probation or parole? He told me no. Then I asked him if he had a conviction in March of this year, whereby he was placed on a term of probation. He again told me no. And then when I reiterated what his criminal history says to me, he then says, oh yeah, he doesn't dispute it. He was not sure. I have concerns. Either there is some mental issue that he probably needs to be evaluated for, or just really no concern about what the behavior that's going on here. I do have here other indications that, of course, the defendant is already on probation or parole or have other criminal matters pending, that the defendant has a history of violent behavior directed towards this victim, and that there's a history of threatening and or harassing behavior toward the victim or witnesses, that there was an intimate relationship between the parties, and that there's an escalation of violence demonstrated by the defendant, and that these alleged actions involved strangulation, and that there are other domestic violence offenses on the defendant's criminal history and a history of probation violations and instability as it relates to following court orders. The people are requesting $150,000 cash bond The court will amend that. The court will issue bond in the amount of 50,000 cash with GPS tether and victim notification. While out on bond, if bond is posted, you need to appear to all of your court dates. You need to report to pretrial services within 48 hours for supervision. You're to test, I'm ordering that you test randomly for drugs and alcohol. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to possess or use drugs or alcohol without a valid prescription. There's a no contact order that will be in place for the protection of the victim. That being an Alyssa Johnson. You're not to be within 2,000 feet of wherever she is for any purpose at all. Do you understand that?
Yes, Your Honor.
Are you sure you understand that?
Yes.
You're not to make contact directly with Alyssa Johnson or indirectly. Indirectly means you can't have anybody else call her, you can't call her, you can't DM her, you can't write her a note, you can't communicate at all with her. Do you understand that?
Yes, Your Honor.
Mr. Lee, did I provide you with the probable cause conference and preliminary examination dates?
Not yet, Your Honor.
Okay, schedule for probable cause conference Thursday, December 7th at 8:30 before Judge Michael Anthony Flores. A preliminary examination is going to be December 14th, 2023 at 8:30 in the morning. Preliminary examination will be in person. You can appear via Zoom or in person for the probable cause conference. If you are unable to post your bond, a writ will be issued to have you transported to the court. Do you have any questions, sir? Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir. On the record in the matter of the people of the state of Michigan versus Michael Goforth, file numbers 23-02614 FT and 23-02600 SM. Counsel appearance.
Assistant Public Defender John Lee on behalf of Michael Goforth.
Yes, sir.
Mr. Goforth?
Yes, ma'am.
Okay, I have here first taking file number 23-02614 FT. You were before Judge Ward for a motor vehicle UDA. It looks like you took a guilty plea and you were supposed to appear for sentencing. You were supposed to appear to probation so that they could do a pre-sentence report. You failed to appear to probation, so a bench warrant was issued. Why didn't you turn yourself into probation as ordered by the judge?
A family member of mine ended up passing away.
I apologize for your loss. When did your family member pass away?
About a few days before I was supposed to, the 10 days.
What was the day your family member passed away?
Day?
Yeah, the day.
A little bit before Thanksgiving
I
was
want
the
the day.
24th.
I want the day. What day was it?
The 16th.
The 16th of what month, sir?
November.
Of December?
November.
Of November? Oh, okay, I apologize that that happened. However, you were supposed to report in October to probation. So your family member had not passed away. Why did you not appear?
So that was the reason, and then also it was a part of my fault also. I should have been more accountable for that. My apologies.
Oh, okay. Okay, well, I'm gonna remand you to see the judge, and then you're gonna have a new referral to see probation, so that they can provide the court with the pre-sentence report and recommendation, okay? File number 23-02600. Again, you failed to appear in that matter. You were supposed to be before Judge Ward. In October. And that would not have been the first time you failed to appear on this file. The matter is going to be set for new pretrial. It's going to be December 11th at 10:30 before Judge Ward. And your bond is set at $5,000, 10%. You have any questions?
On 5,000, 10%.
That's correct.
Ma'am, could I got a job that I'm really not trying to lose. Please. I understand. I did miss that court date.
I recognize that. You'll see Judge Ward next week, and you can ask her for a new bond.
Please.
You're all set, sir.
It took me forever to get this job. I really don't want to lose it again.
I recognize that, but the bond warrant, the bench warrant from Judge Ward requested your remand, and so you're being remanded to see the judge that you're before. You're all set. On the record in the matter of the people of the state of Michigan versus Jack Reed III, file number 23-034 or 3587, counsel appearance.
Assistant Public Defender John Lee on behalf of Jack Gray Reed III.
You're Mr. Jack Gray Reed III?
Yes, ma'am.
Okay, Mr. Reed, I have a citation here. This is actually people of the city of Lansing versus Jack Gray Reed III. It alleges that on or about November 28th, 2023 at 7:24 p.m. in the area of South Washington Ave at or near Washtenaw, city of Lansing, Needham County, state of Michigan, that you did allegedly commit the act of trespass upon the property of another, that being a Domino's at 234 South Washington Avenue. And so you have the right to a trial because that's a misdemeanor. The maximum penalty is 90 days in jail and or $500 in fines. You have the right to be represented by an attorney at all of your court dates. And if you're questioned by law enforcement, if you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you. Do you understand that?
Yes, ma'am.
You have the right to plead guilty, plead not guilty, or stand mute. You have the right to remain silent because anything you say can and will be used against you. If you stand mute, this matter will proceed all the way to a jury trial. You have the right to a jury trial. And you have the right to the presumption of innocence, so you're innocent until the people can prove you guilty by proving each element of the charge of trespass beyond a reasonable doubt. You have the right to confront and cross-examine in court any of the witnesses that the city calls against you, and yet you have the right to call your own witnesses to your trial or present evidence at trial that you believe further a defense to the charge of trespass. Do you have any questions so far?
No, ma'am.
You have the right to remain silent at your trial and not have silence be used against you. You're currently scheduled for a pretrial conference December 12th at 9:30 in the morning before Judge Cynthia Ward. Did you get a copy of your notice to appear?
Yes, ma'am.
Is he requesting public defense counsel?
Yes, he is, Your Honor.
And the court will enter a plea of not guilty on your behalf. Are you employed?
No, ma'am.
Where do you live?
I don't have a permanent address.
Where do you receive your mail?
The DHS building.
You have a caseworker there?
Yes, ma'am.
What's your phone number?
Not off the top of my head.
So you have a cell phone?
Yes, ma'am.
You can address bond counsel.
Thank you, Your Honor. Mr. Reed does have a couple of other matters pending in the East Lansing area in regard to disorderly conduct. But neither those charges nor these charges are violent in nature, certainly not felonious in nature. He does have ties to the community in that he has lived here his whole life. But as has expressed to the court, is in the foster care system. So we're asking the court to consider a personal recognizance bond on Mr. Reed's behalf.
I don't have his prior criminal history, but this is a citation issued for the city attorney's office. The court will grant a bond, $300 personal recognizance. You need to appear to all of your court dates, sir. You need to provide the court with your phone number and an address where you'll be staying within the next 48 hours, okay? I can't hear you.
No, I was talking to myself.
Did you hear my question or my statement?
Yes, ma'am, to something you said.
Okay, what did I tell you that you were gonna do? What did I tell you you needed to do?
Honestly, could you tell me again, please?
Are you awake?
Yeah, I'm awake. A lot been going on, so it's.
Oh, I can imagine a lot has been going on, and you got more things coming up. You got matters pending in East Lansing, and then you have this matter. And so you need to make sure you keep up with those dates, but you also have to make sure you follow the court orders while you have these matters pending, unless you want more things to come up. Do you understand that?
Yes, ma'am, but it's not even the court things that is the court
I
thing
recognize that.
since I was little, so that doesn't affect me.
I recognize that you've been in the system since you were little and that you're currently in the care of foster care. I recognize those things, sir. My report does not indicate that you're under 18. Are you under the age of 18?
I just turned 19 in October.
Okay, and so you can keep up with your court date then, can't you?
I always do my part on my end.
Okay, so I am telling you that you are required to update the court with your phone number within 48 hours because you say you don't know it off the top of your head, okay? Did you hear me?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Okay, also while out on bond, you're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. And again, you make sure you come to your court dates, okay, sir?
Yes, ma'am.
Okay, you're all set for today.
My son. Like he's a bunch of
Well, the state of Michigan versus Sandra Trice. File number 0808348.
Hello.
Hello, are you Sandra Trice?
Yes.
Okay, Ms. Trice, this is a collection file that I have here from 2008, and then there's another matter 13-04805 that you have some balances on that you were supposed to be making payments on. You owe the court $7,708. Plus there's been some late fees. So now you owe $7,518.53. And the last payment, it looks like, was in January of $20. And then you made a payment prior to that of $10 in October of 2022. You did make a payment of $100 back in September of 2022. Looks like you did make a payment of $60 back on August 1st of 2022, but you haven't been here for almost 11 months for a payment.
I had a stroke. I was in the hospital for a month and a half, and I was in the nursing home for a month and a half.
Okay, they have set your matter for a show cause. You are supposed to appear for collections show cause. It says.
I had no clue of that.
I'm sorry?
I had no clue of that.
Say it again for me.
I thought it was over with.
It's not over with, ma'am, because you owe this large sum of money.
But I could stop at paying, but I thought it was over because of my condition I was in.
You thought it was over because of the condition you were in, you said?
Yes, but if I have to stop at paying, I will. And I get paid on the first, I will start paying it then.
Yes, you don't, your balances and your restitution don't just go away, ma'am, just because you're having medical issues. And I do understand that you've had some serious medical issues, and obviously you would not be prioritizing making payments on this while you're dealing with your health. But this matter is still lingering out there and you still have these balances. I'm trying to understand what the balances are for here. There was a false pretenses and then a retail fraud. And it's the false pretense that you owe the largest amount of money on. I don't know if any of that is restitution though. Let's see.
Yeah. Yeah.
Restitution. Okay, this is restitution, which means you owe a victim this money. And that's why the court can't do anything about that file where you have to make those payments because you owe someone money, okay?
I will pay that.
Okay, when are you gonna make a payment?
On the first.
You'll pay on the first?
Yes,
How much are you gonna pay?
$100.
Okay, and so are you going to make a payment on the first of each month?
Yes,
How much are you gonna be able to pay?
$50. I can pay
$50?
$100 on the first, and every month I can pay 50 because of my rent.
Okay. I'm gonna note that here in the file. You make sure you write it somewhere so that you can remember it. And then, so long as you're compliant with that, you won't get another bench warrant issued. If for some reason your situation or your finances change, you need to try to contact the court so that they don't issue a bench warrant, but they amend your payment plan, okay?
I will make that payment.
Okay, you're all set. I'm sorry?
Thank you.
You're all set.
Thank you.
What did Daniel say?
Wanted to know if you could take over and send you down to ask a couple cases.
Yeah, I have a landlord-tenant case I need to do. I'm sorry?
I can have them come back in.
They actually have a hearing that's continued though, so. There's one more person in custody?
Yes, ma'am, we have Mr. Reynolds in the room.
Oh, okay, let's see. Okay, on the record in the matter of the people of the state of Michigan versus Brian Reynolds, file number 23-035991 FY, and then I have 23-02029 OM.
I just recently got out of jail and they was withholding my Social Security because I was in jail for so long. They also stated that my Social Security would start back on the first. And I'm having a lot of medical issues.
We can remand him. I don't have time. I have another hearing and I'm not gonna go back and forth with someone who doesn't want to be quiet for me to advise them of their rights. And you need to take whatever's on your head off.
Sure.
Okay. Thank you. I have a felony complaint here. It alleges that on or about November 29, 2023 at 3258 North Waverly Road, City of Lansing, County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of police officer assaulting, resisting, obstructing. The allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Joseph Traverso, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties, and that this was contrary to MCL 750.81 D1. This is a felony, maximum penalty, 2 years and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement or under the law for another violation arising from the same transaction. You understand the charge and the maximum penalty there?
No.
Okay. What questions do you have about that?
My question that I have about that, you stated that I supposed assaulted a police officer.
I said that you've been charged with a police officer assaulting, resisting, obstructing. That's correct.
Okay. All right. Well,
what parts do you not understand, sir?
My parts that I don't understand, that I need medical attention at this time. Are you refusing that? Or are you not granting that?
Am I granting you medical attention? I'm not a medical provider and I'm not interfering with your ability to get medical provision.
Okay, I would like medical provision, please.
Okay, you'll get medical provision at the conclusion of this arraignment. You have 2 files, or if you'd like, we can get you to get some provision now and you get arraigned later. We can remand you until after you come back from the hospital and we'll see you another day. Is that what you want?
I would like medical attention, ma'am.
Okay, okay. Well, we'll remand him. I can't continue with the arraignment at this time. And I do have another matter that was scheduled at 2:45 that's been, actually 2:30, that's been waiting. So we can remand him. He can be arraigned another time and get whatever medical treatment he needs.
Thank you, ma'am.
Thank you. You're all set. Thank you, Mr. Lee.
Thank you, Judge Simmons. Have a great afternoon.
Same to you. Thank you.
The fan should come down.
Okay, one. On the record, in the matter of Joy Monroe versus Ty Mitchell, file number 23-02136 LT. Both of you ladies, you can come up to the table. Okay, today was the date that I reset this matter for a continuation of a hearing. The plaintiff was to provide evidence of a valid rental certificate, and the defendant was to organize her exhibits and to file an answer and claim for a breach of habitability if that was what she intended to do. I do see an answer to the complaint here filed on November 8th. And let's see. Ms. Monroe, did you get a copy of that answer? Sure. Okay.
Oh, the certificate.
No, did you get a copy of her answer?
No.
And she filed an answer to complaint, and it was filed in the court at least on November 8th. Did you serve her with a copy or did you buy her a copy?
Only to the last time he, the guy handed it to me. I had to sign, I guess I didn't sign it and then he handed it.
Okay. Is that true, ma'am?
He did hand me a paper. I didn't know it was something I had to answer yes or no to.
You did not have to, that was her answer to your complaint.
I'm not sure what paper it was, I'm sorry.
Okay, it's entitled Answer to Complaint to Recovery Possession. That should say that on the top of the page.
What does it say? Recovered to possession of property?
It should say Answer to Complaint.
Answer to. Answer to complaint.
Okay, very good. And so you were supposed to provide or produce some information today. I did, again, look up on the public portal at our last court date, which indicated that you were not in possession of a valid certificate and that it had expired in March of 2022, that it was currently on hold. You indicated that you believe or disputed that and that you believed you could provide information or support otherwise. As soon as a court officer get here, you'll provide that to them, okay? Can you get the paperwork for me? I don't know where Nathaniel is.
He's next door in the courtroom. He'll be here in a minute.
I need that paper now. Will. She's got paper to pass me. Thank you. This is not evidence that you had a valid certificate prior to. This is evidence that you now have a valid certificate, correct?
No, that's the one that said it just expired. I think I circled it. And the other paper stating that I paid to have it renewed a month prior to it expiring. But when I decided to come to court, I called and told her the situation. And she said she was gonna put it on hold. And the lady said, if you have any questions, she wrote her name down, you can call her.
She was gonna put what on hold?
She said I paid to have it renewed.
Correct.
A month prior to it expiring on the 10th. I think it said, I circled the date.
What I see here is that you paid on September 25th.
Right.
To have it renewed.
Yeah. And it haven't even expired yet.
Well, it says this expires on the 1st of October.
But you said I didn't have one in 2022. That's 2023.
That's what the city records reflect.
But that's what I just went and got when I left by the court here. The date is on the page.
This tells me that the certificate was expired, but it tells me that you paid on 9/25 to renew it. That's what this says. You paid to renew it on 9/25, which was after our court date.
No. When we was here?
Correct.
You said I didn't have my information, so I went right down there when I left here. The certificate didn't expire on the other paper until 10/something/2023. I paid that to have another certificate a month prior to that expiring. And she said, Crenshaw, whoever, my paperwork is up to par. She said, if you have any questions, she wrote her name.
Okay, and what information did you have that you wanted to provide the court, ma'am?
Oh, I just have my receipts and stuff that I did pay my rent, and she said that I didn't pay them, and all that, the other stuff where it say lack of the stuff that came from the city, the stuff that you're talking about. I have that too, but it's not like.
It's not what?
I don't know. To me, I don't know. The lack of certificate notice. That
you have a lack of certificate notice, what you're saying?
Yeah.
Can you get what she's talking about, please? Okay, she does have notices here, failure to comply from April 30th, 2020. And then there's a failure to comply from March 9th, 2022. There's a code compliance warning violation from November 30th, 2021. And then there's some photos attached there. Did you have any other paperwork, ma'am, relative to the lack of valid rental certificate?
Yes, it should be the one in the back. Wait. Attached to that. Yeah, it should be in the back. I'm sorry. Close the back right now.
Okay. What are you referencing? Is it a text message?
It's a text message, and it's also the receipts.
Have you provided her a copy of what you're showing the court?
No, she need a copy?
She absolutely needs a copy. Do you have a copy for yourself?
I do.
Okay. And so, the last page is some text messages, is that what you're referencing?
Yes, and my, and proof of, my, receipts that I had, that I did pay my rent.
So this is actually not for non-payment of rent, though, it's for termination of tenancy, correct?
Correct, because I haven't received any rent since 2022, December.
Even if you did, the termination of tenancy doesn't really require there to be a non-payment of rent. Means you no longer want the landlord-tenant relationship to exist.
Right.
And she is saying that she disputes that there should be a termination of the landlord-tenant relationship, and that's because of the conditions of the property. Did you file for a money judgment?
I did. It was.
Okay, so that's what she's trying to dispute, that she did not pay the rent. And she said you're asking, at least at the time that you filed this complaint, for $5,440. And so you indicated that you don't believe, ma'am, that you should have paid because of the conditions of the property, and or that she did not have a valid certificate. You provided evidence here to support the conditions of the property. As I see your evidence as it relates to inspection issues. And to be honest, I'm going to take the evidence also that she provided, and I'm going to have to reconcile that by ordering co-compliance to court, because their records online reflects that you did not have a valid certificate. And I looked that up the date of our last court date.
All right, well, I don't understand how I can go down there and they can say I have it.
We'll find out when they get here and tell us in court.
Okay.
So I'll have them appear. And so this is what, ma'am?
The toilet, it's the bottom of the toilet is leaking. It needs to be sealed down. I need a whole new toilet.
Okay, how long has this been going on?
Since 2021, I'm gonna say.
Okay.
I tried to caulk it myself, but
And did you notify her that there was this issue?
yeah, the city did.
And when did the city do that?
And that, thing right here, and this, when they came and did my inspection in December.
Of 2021?
Yep, of 2021, they did.
When did you take this picture?
It's in my phone, I don't know.
Was it after this 2021 day?
Was it after? I believe so.
You don't know if this is a recent picture?
It is a recent picture.
Oh, okay.
Yeah.
It looks like this now?
All of them is recent. Like all of them, if I go home right now, I can if I FaceTime the kids right now, they can show you everything that's on there.
Okay, so your testimony is that it looks like this now?
Yeah.
And you're okay, and that it was never addressed?
Right.
Okay, and what is this?
That right there is it's another violation. It's the backboard. I did it. I printed it off wrong. But the backboard right here.
Oh,
they
where
said
it's
that
coming off. Okay.
Yeah, they said it's coming off. So as I redid it myself. So it wouldn't.
That was on fire.
That was,
ma'am. I caught the house on fire.
Well, we can end this now. When she talks, you don't get to talk over her. When you talk, you don't get to talk over her. When I talk, neither of you get to talk over me. Do you understand that? Thank you. Okay, there was a citation by the city for this?
No, it wasn't. Not by the city. It was.
Okay.
Yes, I'm sorry. Yes, it was for the for my backsplash. Yes, for the backsplash hanging off. Yes, it was. So I redid it.
Okay, when was that cited?
It's also in that November one, and that it's in the same one.
From November 2021?
Yes.
Okay, and you said you repaired this yourself?
Yes.
What is this?
That's my kitchen sink. The pipe came, it's also in the 2021 complaint. But the pipe came loose and it was leaking all over, so I had to put a bucket underneath there, and I had to keep I had to fix that myself too.
So this is the bucket that I'm looking at
Yeah.
under the pipe?
Yeah.
Is this a recent picture?
No, it's fixed now. I fixed it.
Okay, how did you fix it?
I paid my uncle to come do it. He just put some went and got like a little, I think it's like a little flex pipe or something like that, and put it back and just put it together. So it no longer, it doesn't leak as bad as it was. Oh, that's the picture of the backsplash.
And this is a bathtub?
Yeah.
And what is this that I'm looking at?
The caulk, it's the caulk in the bathtub.
The caulk is black?
Yes.
Why is it black?
I don't know. We had discussed my bathtub getting recalled several times, but it never happened. So I guess this is how it just turned out after the wear and tear.
Is it still in this condition?
Yes.
I'm assuming this is still the bathroom?
Yes.
What are you showing me here?
That's my screen door hanging off, which it actually fell off onto my car, but it's no longer there. That's another thing that was on the violation thing.
Okay, how did the screen door get like that?
When I moved in, it was that way.
Did you report that?
No, she knew that the screen door was hanging, like, cause we tried to fix it several times.
Who's we?
She knew about it, so I tried to fix it several times. I'm gonna say me.
How do you know that she was aware?
Yeah, and I've been living in this house for 5 years, and she knew.
Well, just tell me what makes you believe she knew.
Because we had a conversation about the screen door.
Okay, so you've had a conversation
Yeah.
about the screen door. What's happening here?
This is my door frame. The door frame is broken because you can't, in my house, the doors you can't open, like you can't.
Is this the
You
same
can't
door?
twist it out. That's my daughter's door. She can't, I can't close her door all the way because she can't get out. The violation thing is a fire hazard because if something goes wrong, my baby can't get out of her room.
How did the door get like this?
It's been like that.
You moved in with doors like this?
I moved in like that. I moved in with that doorknob like that, not the frame, I broke that frame because my son was in that room. I broke that frame, I did, because I had to get him out.
So what your testimony is that the doorknob was like this from the time you moved in?
Mm-hmm.
Is that a yes?
Yes.
Okay, and then that the door frame got broken because?
My son was stuck in the room.
Okay, so you was breaking the door?
I pushed the door, yes, I pushed it in to get, yes.
And when you moved in, the doorknob was broken and she was aware, is your testimony?
Yes.
How do you know she was aware?
She knows because we had several conversations about the doorknob not turning.
What's going on with the paint here?
It's from the door frame when it came off.
Oh, okay.
Yeah. But I told her I will replace that. Like I told her I will fix that because I did tear that up. But she still has the doorknob still has to be fixed.
And the doorknob you said looked just like this when you moved in?
Mm-hmm.
Is that a yes?
Yes, ma'am.
This looks like an outlet.
It is.
Is it burnt?
Yeah, I don't know. It's not burned. It looks, I think it's broken, but whatever, you can't use it because when you use it, it turns off everything and the whole house shuts down.
Okay, was she cited for that?
Yes.
On the same date?
Yes.
I don't know if I see that on here. And you said it looked like this when you moved in?
The doorknob?
No, the outlet.
Yes, the outlet, my outlet, yes. They came and fixed some of my outlets.
And this is the same issue that you discussed before as it relates to the
with the-
doorknob? Is that what you're showing?
Yeah,
What's happening here?
that is my dryer outlet. The dryer outlet, I thought my dryer was broken, but I had the what is it called, the repair thing from Consumer Energy. So when they came out to fix my dryer, they said that it's not my dryer, it's the socket. The socket is something is wrong with the electrical thing, so it's a fire hazard, so they had to turn the breaker off. So I haven't used my washer and dryer in over a year. Now that probably wasn't cited for, but that just happened recently. Not recently, but probably last year or so.
So after 2021?
Yes.
We're looking at here.
This is my light in the bathroom. The lights in the bathroom don't work, so you have to put that's not in the thing either. But the lights.
There's no lights at all in the ceiling, you mean?
There are lights up there, but they don't work. Like, yeah, I changed all the light bulbs, I flipped the thing and did all that, and they won't come on. So I just plugged the lamp into the socket, and that's what we use.
Did you report that there were no lights?
No.
Why not?
I think I reported it to her maintenance man, the guy who's supposed to come fix the stuff in my house.
She has a maintenance man?
Somewhat.
What's his name?
His name was Mike. I don't know if he still does it or not.
How did you report this to him?
I think I called him.
Why didn't you report it to her?
Because she always say, call Mike.
How long has this been an issue?
What? Everything.
What are we talking about here?
Everything, the light?
Yes.
Oh, that's been about a year or two, maybe a year and a half.
I have some text messages here.
Mm-hmm.
Is that a yes?
Yes, I'm sorry.
Okay, and then who's in the white?
Joy is.
And then who's in the blue?
I am.
Okay. December 14th. What year was this?
This was just last December.
Okay, what's going on with rent on December 14th at 9 p.m.? She texted you back on the next day. No response. You text back, I'll be by next week. She says, okay. December 26th. What day can I expect rent? You don't respond for a week. Once again, she says, when are you paying December rent? January 2nd. You said, I'm not sure what your problem is with now, but all this smart talking and rude text is not cool. I haven't disrespected you at all, but you still haven't given me a lease. No one has came and did my plumbing in over a year, and I haven't said anything to you about it. I haven't tore up your house.
Then I sent her the pictures of the
I don't see any dates of when this was sent, but I see it. This says Joy Landlord. I'm not sure what problem is. Oh, okay, so this was another text coming after this text is what you're saying?
Mhm.
Okay, is that a yes?
Yes, I'm sorry.
I just, because we have to make a record,
Yes,
so
I'm
we need to know
sorry.
what you're saying. Okay, and then white again, was that Miss Joy?
Yes.
Okay, when did you say you need a plumber? And yes, I get irritated every time rent is due. I have to text you and ask your rent was due in December, not January. What's wrong with the plumbing? Still haven't received December and January rent. This is almost 10 days later. If I don't receive it by next week, I'm going downtown to file an eviction notice for 44414 Barclay Lansing.
Oh, I didn't even
You said, my rent been in your mailbox.
Yeah.
She says, I didn't receive it. I don't really know what date this is because it doesn't indicate. You said, I don't know why you didn't, but it was in case union envelope with your name on it. She says, I didn't receive it. This is why I have asked you to text me when you put rent in mailbox. I didn't receive no text for that info. And then you have pictures of what appears to be some cashier's check, payee Joy Monroe. One was for December 28, 2022 for $1,650. And then I see one for February 23rd for $850. And you've not paid any rent since then?
No.
Okay. And so your position is that you inspected this house before you moved in 5 years ago and it looked like this and you moved in?
Not all the way like that, but it was a lot of wear and tear in there.
Okay, and so why didn't you notify her of a plumbing issue? Because the text messages you provided as your support indicates she was not aware. She asked you, why didn't you let me know?
Oh.
I don't see where you responded.
I didn't respond to her. I didn't, because the plumbing is in the violation paper.
Because the plumbing is in the violation paper?
Yeah.
Okay, and then, ma'am, as it relates to the conditions of the property, did you know about any of these conditions?
No, I know about a door being kicked in and broke. Mike George, my maintenance man, told me that her and her boyfriend was fighting and they kicked the door in and it was, she tried to fix it and blah, 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 but no, compared to that, no. If on the text message, you can see me asking her, what's wrong with the plumbing? She didn't even respond. Therefore, all those issues she's talking about from pictures look like it might have been there, but I have the receipt of the compliance. Why didn't they catch none of that? All this is probably her wearing tearing on the house. I'm sorry?
What receipt of compliance?
My certificate.
Oh,
I said it just expired.
That when you came here the last time, I asked you when's the last time you had an inspection and you told me you hadn't had an inspection.
It just expired.
No, that's not what I asked you. I asked you about a sticker. I said, when's the last time did they come out to do an inspection? You told me that they had not been there. That's what you told me at the last hearing.
I'm due for an inspection.
They have not been there.
Right.
So how could they give you a certificate if they hadn't been there?
It goes every 2 years. I'm due for another inspection.
In between those 2 years, you had a compliance issue and they had to come back out to re-inspect, is what they said. That's what they said. You had a compliance issue, you were supposed to have a re-inspection. I asked you at the last court date, did you have the re-inspection? You told me no. And then you told me that your certificate was on hold. You said that on the record.
Yeah, I asked them that.
Now all of a sudden your certificate's not on hold, you have a certificate.
That paper I just gave you, said my certificate just expired 10, I don't know the date, but I circled it on that paper. It just expired, ma'am.
I recognize that. That's why I'm ordering code compliance to come here, because we have conflicting information from their public website indicating that you did not have a valid certificate, and that information that's on their website actually is consistent with the exhibits that she or the tenant has entered as it relates to the compliance issues. The compliance issues, which I asked you about the last court date, I asked you, did you have them come back for a compliance after they stated you were supposed to be re-inspected? You told me they hadn't been there. And so I have that last year, 2022, in April, you were supposed to be re-inspected because of the compliance issue, and you had not been re-inspected. So I question how you could have a valid certificate if you weren't re-inspected. Maybe you did have a certificate and it was that was supposed to expire on the 1st of October, and it was on hold because you weren't re-inspected. I don't know, because I don't have code compliance here. And I have conflicting information, so I'm gonna have to order them to appear so they can provide further information to clarify both what their website says and what happened in between these code compliance violations and when the last time they were inspected or inspected your your property. I'll be frank, I don't believe you would move in, I would hope, into a property that looked like this.
I didn't.
And so you lived there for 5 years. If you lived in or moved to the property and are having these terrible issues, why would you want to stay there?
I don't know. I like my landlord and I had we was okay. Like I don't know what happened, but we was okay. Like things was getting done, things was happening. Like everything was going.
So things were getting done.
Things was getting done, and then all of a sudden it just stopped.
Okay, but it's been a year since you sent this text message that you haven't gotten anything done.
Yeah, it has. When was the last time she been to my house though?
You said this was December of last year. You told me, it just says December.
Yeah.
And you said you haven't gave me no lease and no one came and did my plumbing in over a year. When were things getting done?
It was getting done before. Like I'm gonna say a year or two ago. Like she was on it. She was, and then all of a sudden she just changed. Like I don't know.
So why would you want to stay there?
Because I like my house. Like I don't know. Like
so you don't have an issue with habitability if you like it there. You're comfortable?
I guess not. Yep, I guess so.
You're comfortable there?
Not really. No. No, it's just I can't find nowhere else to move right now. So.
Okay, so tell the truth.
Yeah, I can't find nowhere.
I'm asking you, why would you want to stay there?
I don't want to stay, but I can't find nowhere to move to though.
Ma'am, do you want to say something?
She just said everything was fine. I stopped going over there when the rent stopped. I'm not gonna go over there and take care of everything she tear up if she's not paying me my rent. She said she haven't seen me in a year. I haven't seen my rent in a year.
That's evidenced by the text message you submitted. They're not? I see the text messages.
Listen.
She asked you, where's my rent? And ghost. Go. What did I say about when I talk? Okay. She asked you, where's her rent? You don't respond. She said, no respond. Then you finally kick in, I'll be by next week. That was on the 15th. 26th come, you didn't celebrate Christmas. I'm sure you bought Christmas gifts for your children, but it don't sound like you paid rent. New Year's, now we're in a whole new year. She's still looking for her December rent. It's a year later. And so I am only at this point ordering co-compliance here so I can see how much past due rent under the money damage you're gonna owe. That's all I'm looking for. You don't get to live in people's property for free. And if you have an issue with habitability, there's a mechanism for it. And you were supposed to escrow your rent and notify her of the issues. She indicates in the evidence you provided to me, she didn't even know there was an issue. She asked you, when was the issue? And then you didn't even respond. So you, as an adult, you need to take care of your issues far more accurately and succinctly than that. But she says you owe a hefty amount of rent. Based on these pictures and the evidence as it relates to habitability and these notifications from co-compliance, have reason to believe that there may have been some breach of habitability. I don't know how much. I need to talk to co-compliance and see when the last time they inspected this place and was she granted a compliance after the last time they came, which was in 2022. And so we'll do that at the next court date. I'll give you a continuance date at this time. We can do December 28th at 2. December 28th at 2. Does that work for both of you?
Yes.
December 28th?
That's December 28th at 2 p.m. And the court will subpoena the appearance of co-compliance. And I am going to keep your exhibits here in the file. And ma'am, you have not necessarily submitted any of the exhibits other than the receipt that you have. Did you need this receipt back? I can take a copy of it.
You said you wanted it?
I'm just gonna make a copy of it.
Okay.
Can you make a copy of this too for me, please? And were you looking to enter any other exhibits?
I don't need to bring anything else. I don't want to come and not be prepared.
I'm gonna have a copy of this. You can bring anything that you believe that supports your claim that the property was habitable and that wasn't an issue. Anything you have to support that, you have the right to bring that in. That's why I was asking if you had anything else at this time. I'll get code compliance. Code compliance can come in here and say, no, we did inspect her property, she was fine. Or they can come in and say, no, we haven't been there since 2022. I don't know what they're gonna say. All I know was on their public website, which at the time of the last hearing, when you weren't able to provide any information at that time, in order to try to expedite this process, I pulled that information up and I contacted the city of Lansing, and they verbally confirmed what was on the website to me.
I don't understand how that.
That's
works.
why we're gonna get them to come in court and explain that to us both. And so you get your notices to appear. Thank you for your patience today as we did the arraignment. And we will see you on the 28th of December.
Time was it?
At 2 p.m. Thank you.